Okay, so Hart versus Fuller. The Hart-Fuller debate has been around since 1958, and the debate is still very much vibrant. The central focus of the debate is whether law should be viewed as law as it is or law as it ought to be. Professor Herbert Lyon Hatfield Hart, born 1907 to 1992, of the Oxford University, took the view of supporting legal positivism, where law is viewed as law. It is a simple rule of command that's separate from morals. Okay, Lon Fuller, 1902 to 1978, of the Harvard University, on the other hand, took the opposite view, where law is viewed as law as it ought to be, and it coincides closely with the morals. In my analysis of the Hart-Fuller debate, both Hart and Fuller provide strong points to support their position. However, Fuller's theory and argument has a stronger case, and this is why I say this. Okay, I mean, in his literary work, Positivism and the Separation of Law and Morals, Hart argues three main concepts: the command theory as law as a social rule, number one, right? The separation of law and morals, number two, and number three, clear legal concept. In his first argument, Hart presented the thought of Austin in the command theory of law. The command theory is basically viewed as a law of command that is backed by the sanction of the threat by an uncommanded commander. Okay, it is a strict method to control people in any given society. Everyone in this society is obliged to follow the law, whether he likes it or not. It is as if the government is the gunman forcing the law. Okay, a gunman enforcing the law. Alright, so Hart does not fully support the command theory of law, but throws a twist to this theory. Okay, he argues that law are not beyond. Okay, well, they're not obeyed. Laws are not obeyed because they're coercive. They demand the demands of the government. Alright, so, but rather obligations which stems from the social rule and norms. Another argument he proposed is law and morals are separate. Hart believes that the law and morals are separate. There are areas where law and morals may seem to coincide, but without the governing authority's seal of approval, it cannot be law. Any morals are nullified in the context of law. Hart argues that rules that confer rights need not be moral rules or coincide with them. Right exists under the rules of ceremonies, games, and in many other spheres regulated by rules, which are irrelevant to the question of justice or what the law ought to be. Nor need rules which confer rights be just or morally good rules. Hart gives an example of the slave. Having a slave might be seen as immoral, but it was legal to have slaves in the context of the law. The society has given its blessing to the law regarding ownership of slaves. The master had full ownership of their slaves. As you can see, law really does not need to coincide with morals. Thus, a system of rules which fail to satisfy a moral minimum could be a legal system. Alright? To further support his argument, he promoted the idea of a legalistic system. Law is not always clear when words, vocabularies, and grammars used are interpreted by different individuals. Depending on how the words are phrased, there could be a penumbra, or a core of settled meaning. The penumbra is the shadow of ambiguous ground, which is not clear. The core of settled meaning in the area of the law that is clear. Okay? Hart provides an example of a vehicle which is prohibited in the park. The vehicle is not exactly specified. It could be a car, a bike, or even a plane. But Hart argues that we need to have a core of settled meaning and be clear on what is exactly at the heart of the matter. The core of the settled meaning is, well, in this case, would be a car, as it is the first thing that comes to mind when one thinks of a vehicle. However, a bike or plane would fall under the penumbra umbrella. When these ambiguous facts are presented, the judge has to decide on which facts fall within the law. Okay. Now, in the case of the Nazi informer, naturalists viewed that outcome of this case as a win for the law of nature and the death of the legal positivism. In Nazi Germany, an individual who criticized Nazi Germany regime were sentenced. The main facts for this case are as follows. I quote, "In 1944, a woman wishing to rid of her husband denounced him to the authority for insulting remarks he had made about Hitler while home on leave from the German army. The wife was under no legal duty to report his act, though what he had said was apparently in violation of the statutes, making it illegal to make statements detrimental to the government of the Third Reich or to impair by any means the military defense of the German people. The husband was arrested and sentenced to death, apparently pursuant to these statutes, though he was not executed, but he was sent to the front. In 1949, the wife was prosecuted in the West German court for an offense which we would describe as illegally depriving a person of his freedom. This was punishable as a crime under the German Criminal Code of 1871, which had remained in force continuously since its enactment. The wife pleaded that her husband's imprisonment was pursuant to the German Nazi statutes, and hence that she had committed no crime. The Court of Appeal, to which the case ultimately came, held that the wife was guilty for procuring the deprivation of her husband's liberty by denouncing him to the German court, even though he had been sentenced by the court for having violated a statute, since, to quote the words of the court, the statutes was contrary to the sound conscience and sense of justice of all decent human beings. Alright? So, this case was resolved by the naturalist's point of view. The act committed by the woman was so cruel that it deprived another individual of his freedom. Hart, however, viewed things differently. He viewed that the Nazi Germany regime as an evil regime. Nazi Germany's law was so corrupt and immoral that natural lawyers like Fuller argued it cannot have any binding power. Hart argued that morality have no place in law. The law may still be law, but just too evil to be obeyed. Alright, the decision of the German court to sentence the woman is one that Hart disagreed with. Hart would have inclined to solve this case by the retrospective criminal statute. He preferred to have a retrospective decision-making process because it does two main things. Integral structure of the law and the woman's accountability. First, it maintains the integral structure of the law. The law will not be thrown out as not legally binding. Instead of having the integrity of the law on trial, the retrospective active criminal legislation will not override any previous law, but legally making new laws to sentence anyone committed of a crime, even if those crimes were committed during the Nazi regime. If we dismiss the idea that any immoral law as not being law, it opens up a whole new world of